Chief Counsel of the ACLJ, Jay Sekulow, is joining us. And, Dad, what we're seeing again is the Democrats, they're back trying to tell Americans who they can vote for, this time in Nevada.
Yeah, this is a trend we've seen, and that is these attempts to deny the American people choices that are really put in place by duly authorized campaigns. The fact is, as you said, Jordan, we're representing the Green Party. And by the way, this is not the first time that we've represented groups that ideologically you may not line up with, which we've represented the Hare Krishnas, we represented the National Democratic Policy Committee at the Supreme Court. So, I mean, you do cases where it impacts, as you said, you put your money where your mouth is and you live the principles that you believe in. What happened to the Green Party in Nevada is so outrageous that the Democrats did this, and that was they were about to submit their form that they used to get candidate signatures so you can get independent third parties on the ballot. They got enough of those that the state certified it. The state actually sent them, the Secretary of State's office sent them a form, and that form that they used was the form that the state wanted them to use to gather the signatures that had certain designations on it. They used that form. They originally were going to use a different form, but they used that form. And then when they turned it in, the National Democratic Policy Committee files a lawsuit, and the court says, oh, yeah, the form that the state told you to use, that was the wrong form. Therefore, you're off the ballot. You talk about outrageous. That's about as outrageous in an election as it gets.
Yeah, so you've got the Democrat Party comes in on the final day to make challenges to those who have applied to get the signatures, petitions that you need, signatures to get on the ballot. And the Democratic Party comes in to say, no, the Green Party, they used the wrong form. Secretary of State's office, they actually sent in the form, Dad, to the Secretary of State's office. It was actually the correct form. And then the Secretary of State's office sent back and said, no, you need to use this form. The Secretary of State is an elected Democrat and a party in this case that we brought to the U.S. Supreme Court. And so you've got a Democrat Secretary of State and the Democrat Party hand in hand trying to stop the Green Party from, after following all of their rules, which is important to our case, and because of the constitutional arguments we make. I mean, let's walk people through that. The first one, due process. The idea here that you go before you ask the Secretary of State, you show them what you're planning to use, and they say, actually, you should use this document. And courts have said over and over again, you can't be punished by following the state who had the correct authority there by following their rules.
No, here's what it means. It means the state of Nevada told you to use a particular document. You use the document pursuant to the state of Nevada's demand. And then the state of Nevada, the same officials tell you, oh, you used the wrong document. You cannot have your votes counted. I mean, that's what they've done here. And that's why we were joined with of course, we're representing the Green Party and with two other advocacy groups that, again, don't line up ideologically, but this is not ideological. This is law. Can the states do this? And the answer better be, when this is done at the Supreme Court, the answer better be no. We're at the Supreme Court right now. And like you said, Jordan, we got there in 24 hours.
And there's also the equal protection argument here, Dad, as well. Again, this idea, when you go before these courts and like on this matter, and you've relied on all from the Secretary of State, and then you're completed, and that they used in this section that it didn't have this one area where it said you have to verify or believe, not verify, believe that the person signing is a registered voter. But on the form they got, it was for if you wanted to get like a constitutional amendment or something put forward in the state, that language isn't there. Now, that language was there when the Green Party filed with the Secretary of State. And the Secretary of State said, no, that's the wrong form. Here's the form back. But it really doesn't matter, that language, Dad, on the equal protection side, because the County Board of Election, the registrars, have to certify that those signatures came from real registered voters.
Correct. And to put a referendum on the same ballot in the same process in Nevada, you don't have to have the form as the Secretary of State gave us. So this is where the equal protection comes in. So this is a violation of due process and equal protection. It was a 5-2 decision. It's interesting. The two dissenting justices are Republicans. I don't think this case necessarily falls legally on ideological lines, but I thought that was interesting. It's going to move very quickly. As I told our team last night, Jordan, once we filed, as you said, at 10:14. Now the court has it, and they will set the pace, and it's going to go very, very quickly.
Yeah, talk to people about that as well, the speed here. I mean, our team, by the time we got everything signed and done, I remember getting the phone call in the evening to say, could we assist? I said, yeah, I think we can, as long as they want to partner up with us. I think we'd be great for this. And when we got the official, sign off that we could represent the Green Party with our co-counsels here, but be the counsel of record as you are, and this was turned around to the U.S. Supreme Court in 12 hours. And what we're asking, let's tell people what we're asking the court to do, Dad, because this is something where time is very important.
Yeah, so because the ballots have to be printed and early balloting starts very soon, we've asked the court to take the petition that we filed. The application is actually an application for a stay and a summary reversal, basically, turn it into a cert petition, which means then the court takes that application, the same court, and says, no, we're going to consider this a cert petition, grant the cert petition, and get the case over with, maybe with no additional briefing. There may need to be additional briefing. That's going to be totally up to the court. But our team moved in record speed and filed a great document.
Well, I think, Dad, it's a great example about where people's donations go. They go into a legal team that can take on a brand new client. And those kind of clients, even with those ideological differences, reach out and are glad to partner with us because they know about our legal expertise. They know we did the 14th Amendment case successfully, and they know about the speed. And about the ACLJ, Dad, and the fundraising aspect of it is that to have that kind of speed and to be able to not have to worry about having the funds, that's always because of our donors.
Yeah, and I want to encourage our donors to support the work of the ACLJ by going to aclj.org right now. We filed just this week at the Supreme Court of the United States and at the Supreme Court of Ohio. That was just today, this week. So these petitions are already up. The legal work's been done. Your support of the ACLJ makes a huge difference. And we encourage you to do that at aclj.org.
Dad, thanks for joining us. And folks, there is now information up at aclj.org on this case. If you want to find out more about the case, the brief, what we are doing to defend election integrity, check out aclj.org. And we encourage you, again, support the work of the ACLJ. This might not be the last time we're having to go 24 hours to get to the U.S. Supreme Court to protect Americans' right to vote for the party or the candidate of their choice and to protect the election integrity of this such important election.